No, respond number 2 may be directed, my lord. Two is the competent authority, my lord. No, respond number 2 is the competent authority. My lord, commissioner. Commissioner GHMC is the competent authority to consider the. My lord, obliged. Obliged.
Deeply obliged.
The appeal is preferred against orders petition 2578/19 method. The observation of the lung cell judge method, uh, page 22, of the order method, para 7 method. The contention is that respondent number 5 Sildar has no power to grant succession in favor of the unofficial respondent 6. In fact, the petitioners have made an application on 13/7/2015 and 1/4/17 before the respondent number 5 grant of succession. Once the petitioner filed for application of grant of succession, they cannot contend that the respondent number 5 has no jurisdiction to entertain the application of the respondent 6. If the petitioners have any grievance for grant of succession in favor of R6, they have to approach civil court by filing suit for declaration of title. That was a finding given by the court, and against again the court para 6 malad, page para 8 malad, page 6, page number 23. Without going into the rights of the parties, writ petition is disposed of, granting liberty to the petitioner as well as unofficial respondent 6 to approach the competent authority under ROR Act after disposal of the suit malad, which is filed in the year 21. So, my lord, my understanding is the marriage, the respondent number, the appellants filed an application before the Tahsildar for grant of succession after the death of father, and meanwhile the partition was effected notionally in the year 92 itself, and the legal aids, the appellants filed an application for grant of succession. So, meanwhile, the respondent number 6, who is claims to be the daughter of first wife, claiming the share in the property without approaching the civil court, my lord, in the year 2017, and the Tahsildar without jurisdiction, without directing the parties to approach the civil court for appropriate rights, simply granting succession allotment of shares have been allotted, my lord. So it is against the law, which the MRO has no jurisdiction to allot the shares, my lord, because her marriage was performed in the 1968. Even as per Succession Act, she is not entitled, though she is the daughter of the deceased father, but she cannot claim any right, my lord. So succession cannot be granted to her. So under these circumstances, again after granting succession, the revenue authorities issued passbooks, my lord. My submission.
Let the respondent number 5 take a decision, and if you are agreed, you can take the matter to the subsequent court.
Submission. Page 58, my lord. Order of the Tahsildar. Last year, in view of the above contestants who are the successors through second wife is not maintainable, I hereby order to grant succession land held by Narasimha Rao in favor of the legal heirs of V. Narasimha Rao, only daughter of first wife and second wife, only daughter of second wife, 5 sons, with equal shares as shown below. The shares have been allotted. Succession is different, but the allotment of shares, there is no jurisdiction to the Tahsildar to allot the shares. Again, in the year 21, after lapse, there is no record to show that she is never been in possession at any point of time. So her marriage was performed at 68 without any right. She is claiming the rights by virtue of succession. So again, they filed a suit for partition in the year 21. The respondent 6.
Millets, may I say this? Millet, the suit was filed by the respondent number 6, Millet, for the partition of the property after the death of her father. Millet, during the pendency of the suit, Millet, the appellants filed, Millet, the application before the Tahsildar for succession, issuance of the succession. Millet, being a daughter, sixth respondent also made a Millet objection before the Tahsildar. Millet, being a daughter, Millet, Tahsildar granted succession. But ultimately, the suit has to be decided, Millet, after deciding the suit. Millet, partition has taken place prior to 2004, Millet, as in terms of the Vinita Sharma case, or all these to be examined by the civil court. But Tahsildar, Millet, has not violated anything, Millet, since she raised an objection, succession has been granted, rightly granted.